child abuse. And I think that's something that we have to take a look at. For the last 2 years, senior officials in this administration have twisted and perverted the mission of the Department of Health and Human Services, specifically its Unaccompanied Children program. Statute requires the Office of Refugee Resettlement to, quote, promptly place children in the least restrictive setting that is in the best interest of the child. They are responsible for reunifying them with parents or family in the U.S. as soon as possible. Executing this lawful mission has not been this administration's approach, however. Instead, it has attempted to turn Health and Human Services into an immigration enforcement agency. This is not about administrative agencies going above and beyond to ensure the law is upheld, but it is about senior officials in this administration turning suffering children and overwhelmed caseworkers into pawns in the administration's immigration deterrence policy. And as we know, based on legal precedent, that separation as deterrence policy is illegal. We requested the testimony today of 2 senior HHS officials who were in charge during the start and execution of the administration's family separation policy. That is the former Acting Assistant Secretary of the Administration for Children and Families and the former Director of the Office of Refugee Resettlement. We wanted to ask them key questions because my colleagues on both sides of the aisle need to assess the treatment of unaccompanied children, the effect of the family separation policy, the costs, and so much more. Unfortunately, the administration declined to make these senior officials available, but we will continue to press for them to appear before the subcommittee. So yes, we will hold future hearings. We need to question those who directly implemented this policy. As we know, the administration intentionally separated thousands of children from their parents, and just last month, we learned from the Inspector General that the Trump administration's family separation policy began much sooner, as soon as 2017, with the result that thousands more children were separated. And what we are going to do is to demand a full accounting of these children from the administration. Family separation is only one element of this administration's ongoing sustained abuse of these children. As our witnesses can attest, this administration did not prioritize the health and safety of the children in our care. Instead, through a memorandum of agreement, the administration directed HHS to collect immigration information for ICE, which forced tens of thousands of children to spend additional weeks, sometimes months, in federal custody rather than in safe, supportive homes with family members. What was the result? The average length of time each child spent in federal custody nearly tripled, from about 35 days during the Obama administration to 60 days last year to almost 90 days this year. One of today's witnesses, Jj Mulligan, met several children who had been detained at the Homestead Influx facility for over 7 months. As children spent additional weeks and months in federal custody, the overall number of children in the system swelled to nearly 15,000 in December, a record number. As a result, HHS began to move thousands of children to overflow facilities or influx shelters. These are underprotected, non-permanent facilities. Since they are on federal property, they are not licensed by the states, which are normally tasked with overseeing safety and security standards. The 1997 Flores settlement sets national standards for the detention of vulnerable children, and yet, as our witnesses can attest, there have been many instances of violation of Flores. We know of 2 such influx facilities. The administration detained as many as 2,800 children at Tornillo, again for potentially months at a time. However, there was no education program, and for an alarming period of time, there was not adequate background checks or fingerprinting being conducted on the staff. They had an insufficient number of mental health personnel. Despite this, the administration offered a no-bid contract worth up to $1 billion to the site operator that would expand Tornillo to 4,000 children, $1 billion. We shined a light on the conditions and the standards at Tornillo, and it is now closed. And I look to my colleague, Congresswoman Lucille Roybal Allard, and her efforts in this effort. Yet there are 1,600 children in Homestead, Florida today. It costs taxpayers $775 per child per day for children to stay there. So with the average length of stay, around 70 days, this temporary holding facility is costing taxpayers $55,000 per child. Influx shelters and costs will be the subject of a future hearing. Where's the money going? To whom is it going? How much is being wasted? This is why this matters. By law, the administration should be quickly placing children in safe, supportive homes with family members. And HHS's role is to do what is best for the children. Instead, as part of an anti-immigration push, the administration is trying to turn HHS into an extension of ICE, leaving children languishing in federal custody to their detriment, and they are willing to spend $1 billion to do it. Studies have repeatedly shown that prolonged detention inflicts serious mental trauma, depression, anxiety, post-traumatic stress disorder, developmental delays, and compounds trauma experienced in the home countries, including trauma from gang violence or sexual violence. Now the administration is asking for an additional $220 million for this program. There has been no accountability with the use of these funds. It cannot go on as it currently is. That really is unacceptable. What we have to do is to understand how this happened, why it happened, who was responsible, what is happening now, what has been the impact on our children, what are its long-term consequences, including mental health and trauma. How do we stop this? How do we fix it? And what resources are necessary? I'm happy, and I think people on this subcommittee would be happy to provide resources. What we cannot do is to condone the policies that put children at grave risk and at considerable cost to taxpayers. We cannot throw good dollars after bad. And of course, the failures of this administration as they relate to the Unaccompanied Children program are not because of an unprecedented surge of children. In fact, the number of unaccompanied children referred to ORR was higher in the Obama administration. 2016, 59,000 children. 2018, 50,000 children. The failures and the trauma we are seeing are a result of this administration's cruel policies. Let me quote Michelle Brane, one of our panelists this morning. It's the crisis at the border is a crisis of policy. And I add this, in my own words, that this is a manufactured crisis. As the Congress, we have an obligation to ensure the executive branch is fully and faithfully upholding the law of the land, turning HHS into an immigration enforcement agency, and inflicting harm on scared children is neither of those. What happened and what continues to happen is inexcusable. It is indefensible. I'm committed to uncovering the truth, but what is more important, what are we going to do about it? I'm grateful for the solutions and the recommendations that our panelists have offered. We look forward to working with you, and we look forward to your testimony. Let me now turn this over to my good friend from Oklahoma, the ranking member of the subcommittee, Mr. Cole, for any opening remarks that he cares to make. And I also want to welcome the ranking member of our full committee, Congresswoman Kay Granger of Texas. Thanks for being here this morning. Tom?
Thank you very much, Madam Chair. And I want to first begin by thanking you for, one, holding the brief that we had with the Inspector Generals last week, which was very helpful, or 2 weeks ago, I suppose now, and for holding this hearing. I think it's an important subject, and I think you're to be commended for bringing it up. You'll forgive me if I disagree a little on your timeline, because I would start mine in 2014, not 2017. This isn't a new problem, and you mentioned the, and I agree with you, by the way, the inexcusable problems that we had in terms of sexual assaults at center. The majority of those actually occurred under the last administration, not this one, and I'll submit this for the record. Frankly, and this is sad to say, and this would would be lack of supervision. Most of them obviously were by other minors that were there themselves, not by members of the staff or caregivers. That was true under President Obama. It's certainly true today under President Trump. So I think we've got a serious problem here that's been festering for a long time, not somehow magically arrived in the last 18 months. I want to thank, too, all of you that are here for the hearing. I read your testimony last night, and it's heartbreaking and compelling and interesting. And I think, you know, in your very different roles, really showed a lot of the complexity of the problem that we've got in front of us, and it's going to take some real serious work to try and get this situation to one that we can all find acceptable. Today we have an outside witness panel to discuss the oversight over the Unaccompanied Alien Children program operated by the Administration for Children and Families, an agency under the Department of Health and Human Services. I want to start by saying, again, I take our congressional responsibilities of oversight seriously. Congress's primary function is to serve as the branch of government responsible for writing and passing legislation, and understanding how the executive branch is implementing that legislation is critical to fulfilling our constitutional duties under Article 1. And I want to add parenthetically, I certainly agree with you about the separation of families. That was something I actually condemned at the time, and glad to see the administration, I think under public pressure, quite frankly, backed off on. When people think of this subcommittee, they often think of biomedical research, support for public schools, or job programs. The responsibility for the care of unaccompanied children is relatively new. This duty came to HHS as part of the Homeland Security Act of 2002. Federal law requires the Department of Homeland Security to transfer to HHS any unauthorized minor not accompanied by a parent or legal guardian. The legal requirement means that when Customs and Border Protection or Immigration and Customs Enforcement apprehend a minor with an uncle, an aunt, a grandmother, grandfather, or an older brother or sister, the law defines that minor as an unaccompanied and requires their transfer or that child to HHS. HHS and the Office of Refugee Settlement, which oversees the Unaccompanied Alien Children Program, does not separate children from parents. Let me repeat that. HHS does not separate children from their parents and has not done so in the past. HHS is only responsible for the care of children who are unaccompanied, and this is a statutory responsibility given to them by Congress. I think it's obvious to everyone here that there are significant disagreements between the President and the House majority on matters pertaining to immigration policy. I know my Democratic colleagues are concerned about the administration's action in this area, and I share, in many cases, those concerns. But disagreements over the interpretation or implementation of immigration policy, frankly, fall squarely under the Departments of Justice or Homeland Security. These policy discussions are largely outside the scope of this subcommittee. In 2014, President Barack Obama requested a supplemental appropriation to address, quote, the urgent humanitarian situation on the southwest border, unquote. He went on to request, quote, a sustained border security surge, unquote. This year, HHS made that request. The year HHS made that request was 2014. HHS cared for over 57,000 unaccompanied children, an unprecedented number. Because I dealt with it as the chairman of this subcommittee and trying to make sure that the funds were available. In 2018, last year, the Trump administration cared for nearly 50,000 children. This administration inherited a humanitarian crisis on the southern border. Numerous reports by the Office of Inspector General have highlighted the challenges administering this program, and these reports have documented concerns under both President Obama and President Trump. I believe oversight is necessary to ensure the program continues to care for children in accordance with the law. Last year, as chairman, I accepted over half of all amendments offered by the minority to address oversight and reporting concerns regarding unaccompanied alien children program. I continue to work closely with the chair to ensure the final appropriation for fiscal year 2019 addressed those provisions from the House bill and report. And I appreciate the opportunity to evaluate this program through our oversight role as appropriators. Again, I would like to thank our witnesses for being here today, and I yield back the balance of my time, Madam Chairman.
Thank you very much, Congressman Cole, and it's a pleasure to really, once again, to welcome the ranking member of the Full Appropriations Committee, Congresswoman Kay Granger of Texas.
Thank you very much. I'd like to thank Chairwoman DeLauro and Ranking Member Cole, who also serves as the Vice-Ranking Member for the full committee, for holding this hearing today. The treatment of children Entering our country unaccompanied by an adult is one that concerns everyone in this room. I've been engaged on this issue since 2014, when our country experienced a really unprecedented surge in the number of unaccompanied children, mostly teenagers, coming across our southern border. At the time, I was chair of the State and Foreign Operations Subcommittee, and the Speaker of the House asked me to lead a congressional task force to identify the root causes of the problem and recommend solutions. We took several trips to the southern border as well as to countries in Central America to talk to their leaders firsthand. Our recommendation at that time was that we should keep these children near the border, determine where they came from, and try to reconnect them with their families. We didn't recommend sending them all across the United States in the care of sponsors. We wanted them reunited with their families as soon as possible. Unfortunately, the violence and hopelessness driving parents to send their children on the dangerous journey to the United States has not disappeared since then, but it also did not begin with this administration. The number of border crossings by Central American youth continues to create tremendous challenges for both border enforcement officials and the Department of Health and Human Services, who have the responsibility for caring for most of the children after they enter the country. It's unfortunate that our government has not always done right by these children. For example, we learned that officials in the previous administration placed children with sponsors in Central Ohio who were later discovered to be human traffickers using forced child labor. This is terrible, and we must work together, all of us, to ensure that every child placed in the custody of the United States government is treated humanely and with compassion. This hearing should be an opportunity for us to learn the facts, get the data, and help improve program operations in order to better protect our children. We've proven that we can work across the aisle on difficult situations and issues. I know we continue to rise above our partisan divisions, and when we do, we solve most of the difficult problems facing our country. I look forward to hearing from the witnesses today, all of you who experienced this firsthand, and working with members of the subcommittee on this very important issue. Thank you. I yield back.
Thank you very, very much. Let me again thank our panelists, and let me just do some introductions. Jj Mulligan is a clinical fellow at the Immigration Law Clinic at UC Davis School of Law, Fulbright Scholar at the University of Granada in Spain, focusing on unaccompanied minors crossing the Mediterranean, and is the author of No Human is Illegal, an attorney on the front lines of the immigration war. Jennifer Podkol, Senior Director of Advocacy and Policy for KIND, Kids in Need of Defense. She is a national expert on issues affecting immigrant children and has published numerous articles, handbooks, and reports on U.S. immigration law. Michelle Brane is Director of the Migrant Rights and Justice Program at the Women's Refugee Commission. She is an expert on U.S. asylum protections and detention policies for migrants, and in 2012 won the Daniel Levy Memorial Award for Outstanding Achievement in Immigration Law. Andrew Arthur is a resident fellow in law and policy at the Center for Immigration Studies. Before that, he served as an immigration judge at the York Immigration Court in York, Pennsylvania, and served as senior staff for multiple congressional committees. And Dr. Arthur Stewart is president of the American Psychiatric Association. Dr. Stewart is an associate professor of psychiatry and director of the Center for Health and Justice Involved Youth at the University of Tennessee Health Science Center. Again, thank you all for being here, and we will start with our first witness is Jj Mulligan. Your full written testimony will be included in the record. You are now recognized for 5 minutes for your opening statement. Thank you.
Chairman DeLauro and Ranking Member Cole and members of the committee, thank you for the opportunity to testify before the subcommittee today. I'm the clinical fellow at UC Davis School of Law. It's an immigration law clinic, and I'm honored to be here. As part of Flores Council's legal team, we've been granted access to any and all facilities where children are detained. This is important because congressional and media tours of detention facilities rarely reveal the full story. As our co-counsel for National Center for Youth Law, Alicia Welch, put it, we see a very different picture. We see extremely traumatized children, some of who sit across from us and can't stop crying over what they're experiencing. This distinctive insight we obtained is the difference between believing a detention center is a, quote, summer camp and knowing that it is a house of horrors. Throughout the course of these visits to facilities, we have uncovered numerous violations of the Flores Settlement Agreement through our countless conversations with detained immigrant children. The children also describe policies that prolong their detention. These misguided policies that have rapidly expanded the population of detained immigrant children, which swelled to a record of 15,000 in late 2018, before a policy change only requiring the fingerprints of the sponsor and not everyone in the home, resulted in more than 4,000 children being released from ORR custody within a span of 4 weeks, the largest decrease in the program's history. The change in policy also displayed a clear causal link to ORR policy. Once fingerprints for every household member were no longer required, the Tornillo influx facility was no longer needed and promptly closed. For the unaccompanied minors that we speak with, these are children that have suffered intense trauma and abuse either in their home countries, on the journey here, or both. This is a population that has much in common with the forced child soldiers of civil wars past across the globe, and the federal government is responding to their PTSD with steel cages, causing them to act out until they are detained under even harsher conditions, creating a continuum of trauma that these children are ill-equipped to endure. One child told us he was waiting to be reunited with his mother. My mom has done everything the government has asked her to do. My case manager has told me that they're waiting on my fingerprints for my brother to clear because he lives with my mother. It has been a month since the fingerprinting was done. A mother told us that her son's caseworker, quote, kept asking me for more and more documents, among them files from doctors to verify that my cancer would not hinder me from taking care of my son. These caused me great sorrow, and they did not necessary to have my son. I believe that a mother has the right to take care of her child, even though she is incapacitated, although I'm not. It occurred to me that they were looking for an excuse to deny me my son. In addition to the examples, we have heard from sponsors who are told that children will not be released to their care unless they comply with the following requirements: that they move to a different neighborhood, move to a larger apartment or house, reduce the total number of children in the house, or produce a photo establishing a prior relationship with a child, despite the fact that many families do not have access to this technology. There's also the Memorandum of Agreement, which Chairman DeLauro mentioned, between ICE, CBP, and ORR, which provides for the information collected by ORR or potential sponsor to be shared with ICE. This had a chilling effect on sponsors and has serious consequences. I spoke with one youth detained at Homestead whose father was picked up by ICE shortly after being fingerprinted by ORR and whose detention was being prolonged by his father's own ICE detention. I cannot stress enough the courage and the selflessness it takes for an undocumented immigrant to submit to fingerprinting under this administration. In response to its inability to release children to their family members, ORR has established unlicensed temporary, quote, influx shelters, first in Tornillo, Texas, and now in Homestead, Florida. These facilities have held thousands of children. At Homestead, the facility director has told us that the capacity there will be 2,350, even though some rooms that we visited already held over 200 children in the same room. Both Tornillo and Homestead are unlicensed facilities that do not meet the standards of care in the states where they're located, nor do they comply with the Flores Settlement Agreement. These include the failure to perform basic background checks on facility staff, at times leading to cases of sexual abuse, as we learned yesterday. The harm to children, first at Tornillo and now at Homestead, goes further and includes the denial of basic freedoms and the human contact vital to developing children. The treatment of detained immigrant youth at these facilities is not an issue of immigration law or policy, but of human dignity. Deterrence by mistreatment should no longer be the leading immigration policy of this administration. The children I interviewed at Homestead commented on their inability to have any freedom of movement. All youth, including 17-year-olds, have to get escorted to the bathroom. Youth move throughout the campus walking in single-file military-style lines led by a youth care worker. A girl at Homestead told us, "I also get huge headaches because I don't feel like I can cry here. I wish I could cry here, but I can't cry comfortably. I have to hold my tears because if not, they send me to the clinician. I don't want to go to the clinician because they don't want to help my case. I also want to hug my girlfriends when they are crying, but staff won't let me." Previous court rulings interpreting the Flores settlement have set the grace period for detaining children in unlicensed facilities at 20 days. According to ORR, the average length of detention at Homestead is 69 days. And as Chairman DeLauro mentioned, I spoke with multiple youth who have been at Homestead for over 7 months. Unlike someone in the criminal justice system who will usually know the length of their sentence and can, quote, do their time, immigrant children detained by ORR have told they will be released next week, and that was 3 months ago. The harmful practice of detaining children in huge unlicensed facilities could be ended if ORR would simply abide by the Flores Agreement and release children to sponsors without unnecessary delay. The constant calls to revoke the Flores Agreement by those within the Trump administration in order to, quote, protect children are misplaced and disingenuous. We would not tell a soldier in battle that they are safer without armor. The Flores Settlement Agreement plays a critical role in protecting the safety and welfare of unaccompanied children in federal immigration custody. While Flores Council and other legal organizations will continue to investigate conditions of confinement and bring actions to enforce the letter and spirit of the Flores Agreement, we urge Congress, and it is vital that Congress play its role to ensure that the government of the United States lives up to its legal and moral obligations to the children in its care. Thank you.
Recognized for 5 minutes for your opening statement.
Thank you, Chairwoman DeLauro, Ranking Member Cole, and members of the subcommittee. I'm grateful for your invitation today. I'm here to represent Kids in Need of Defense, a national organization dedicated to promoting the rights of child migrants and ensuring that every child has access to high-quality legal representation. KIND serves both children who are in the custody of ORR as well as children who have been released and reunified with the sponsor while they're going through their immigration process. KIND attorneys work to help children who have undergone unimaginable horrors, to explain heartbreakingly difficult and complex stories. They work to gain the trust of children who have been hurt by adults in their country of origin or even at the hands of our own law enforcement agents. Many children have suffered in detention, and some have been separated from the only caregivers they have ever known. This has always been a difficult job, but it has only gotten harder over the last 2 years by changes affecting the way our government is processing these children. Despite the detention and removal process already being incredibly complex and adversarial, the administration has implemented policies that make it harder for children to be able to tell their stories. Among these is a memorandum of agreement between ORR and DHS that enables the agencies to use information about potential sponsors for immigration enforcement. This policy has led to significant delays in the release of children from ORR and the administration's increased use of large-scale and costly influx facilities. Our government should be working to find ways to make the process more fair, less expensive, and more efficient. Instead, it is stacking the deck against these children. This does not make our country more safe. It does not make our justice system work better, and it does not further any enforcement goals. These policies not only harm children, but they limit our government's ability to efficiently and fairly decide which children are in need of humanitarian protection and which children may safely return home. KIND recently represented an 8-year-old. His reunification was needlessly delayed by ORR. The child began engaging in self-harm, and he asked to be returned to his country of origin out of desperation because of the prolonged detention, despite his mother's insistence that it was not safe for him to go back. In another case, a KIND attorney watched a 16-year-old girl give up her strong asylum application because she was not able to access an attorney in Tornillo, and she had no reunification options. To stop tragic stories like this and to fulfill its obligation to serve the best interests of unaccompanied children in its care, ORR must immediately end the MOA with DHS to stop sharing immigration status information about potential sponsors for the purposes of immigration enforcement. ORR should focus on finding the best sponsor for a child who will provide a safe home and support that child during the removal proceedings. Permanently ending the MOA will allow ORR to again prioritize child welfare over immigration enforcement. Secondly, ORR must only rely on emergency influx facilities to house unaccompanied children when it is faced with caring for an unexpected influx. ORR should use permanent, small, and state-licensed facilities to house children only as long as needed to approve an appropriate sponsor. Children must not be held any longer than necessary. Should an emergency present itself, ORR must have public standards for its emergency facilities to ensure the provision of legal, medical, and educational services within a reasonable time frame. There should also be limits on how long ORR can use an emergency facility. Finally, ORR should prioritize children's access to high-quality legal representation. Children are in ORR custody because of the immigration removal proceedings. Everything possible should be done to ensure that children can fairly and efficiently tell their story. Having children represented during the removal proceedings not only helps the children access meaningful due process, but increases efficiency in a sorely overwhelmed system. Child protection must be a priority in the enforcement of our immigration laws. Congress assigned responsibility for the care and custody of unaccompanied children to the Office of Refugee Resettlement because of its expertise in child welfare. The basic tenets of child welfare must be reflected in the agency's policies, and the agency must always act in the best interest of the children. I'm happy to answer any questions.
It's giving back some time as well. Thank you. Michelle Brane. Ms. Brane, you are recognized for 5 minutes for your opening statement.
Thank you. Good morning, and thank you for the opportunity to present to you today. The Women's Refugee Commission is a nonprofit organization that works to protect the rights of migrant women and children. As the director of the Migrant Rights and Justice Program, I have monitored dozens of immigration detention facilities and ORR children's facilities, and interviewed government officials, children, detainees, service providers, and asylum seekers about policies, practices, conditions of custody, and access to protection. Over the past 2 years, the administration has focused on deterring migrants, especially children, from seeking protection in the United States. Unfortunately, these policies endanger children. My colleagues here today have told you some tragic and heart-wrenching stories about children in custody. I can tell you those in answer to your questions, but now I'm going to focus on 2 policies that jeopardize children's welfare and have obstructed the ability of the Office of Refugee Resettlement to comply with its responsibilities. The first is family separation, and the second, the Memorandum of Understanding of Agreement that Jennifer referred to. Thousands of children migrate to the United States each year. Most of these children are fleeing horrific violence and abuse. In 2003, the Homeland Security Act transferred custody of unaccompanied children to the Office of Refugee Resettlement with the deliberate intention of separating the care and custody of children from enforcement activities in compliance with our child welfare laws and with the Flores Settlement Agreement. ORR was designed to care for and reunify children who arrived in the United States unaccompanied. Yet, we now know that under the administration's family separation policy, thousands of children who were separated from their parents at the border were transferred to ORR custody. By now, you've heard a lot about family separation and the brutal manner in which it's been implemented. There was no coordinated effort to track children who were separated or for how to reunite them afterwards. To this day, the government is unable to give a total number of the families it separated. In addition to causing trauma, separations put multiple burdens on ORR and affects the safety of all the children in its care. These large numbers of separated children in ORR custody required a sudden and immediate increase in bed space. And despite the reality that this had been discussed for over a year by the administration, ORR was unprepared and scrambled to accommodate these children. The facilities they went to were inappropriate for children, unlicensed, and temporary in nature, supposed to be temporary in nature. In 2009, I expressed concern in a review of ORR facilities that they were considering the use of facilities that housed over 100 children. Today, that seems quaint, as we see that Homestead will be housing over 2,000 children, and the recently closed Tornillo held almost 4,000 when it closed. No facility of this size is appropriate for children, yet Homestead is still not licensed, even though it's been open for over a year. At that point, it's no longer an influx or an emergency, especially since, as the chairwoman already commented, this was a manufactured crisis that they knew was going to lead to the need for additional bed space. The repercussions don't end there. The cost, both financially and in terms of manpower, of this policy were and continue to be exponential. Emergency facilities cost up to $750 a day per child. These are resources that could and should be invested in actual services and appropriate care for children, but they have been wasted because of a bad policy intended to harm children and families. In May 2018, ORR implemented a Memorandum of Understanding with DHS. As you've heard, one of the very objectives of this policy was to identify, detain, and remove adults who come forward to sponsor children. The MOA represents a dramatic change in practice, replacing the best interest of children with immigration enforcement. The Women's Commission conducted a survey that found that indeed the MOA has succeeded in frightening parents from coming forward, resulting in longer lengths of stay, and for some children, permanent lengths of stay, or, as Jennifer mentioned, withdrawing of their case out of desperation. The MOA and family separation, like other policies of this administration, are using children as bait and undermine family reunification, the fundamental principle of child welfare law, by turning safe placement screenings into a mechanism for immigration enforcement. This runs counter to Flores. It violates the Trafficking Victims Protection Act. It runs counter to child welfare principles and standards, and it is illegal. It is also against the government's fiscal interests. Let me be clear, seeking asylum is legal. Flores and TVPRA are not loopholes. They are policies thoughtfully and carefully considered by the court, child welfare professionals, and a bipartisan Congress, designed to ensure basic child welfare standards in government custody and to protect children from the risks of trafficking. The MOA and family separation have jeopardized the quality of care and compliance with general child welfare standards and practices, and in doing so, has endangered children. Thank you again for the opportunity to speak to you today, and I can take questions later.
Thank you. Our fourth witness is Andrew Arthur, and Mr. Arthur, recognized for 5 minutes for your opening statement.
Thank you. Chairman DeLauro, Ranking Member Cole, and members of the subcommittee, thank you for inviting me to appear today. The demographics of migrants apprehended at the southwest border has changed significantly over recent years, and it's important to understand that in the context of this hearing. Before FY 2011, 90% of all apprehended migrants at the border were single adults, mostly male and mostly nationals of Mexico. In just the first 4 months of FY 2019, on the other hand, just less than 60% of all apprehended migrants were UACs or aliens traveling in family units, mostly from the so-called Northern Triangle countries of Central America, or NTCA. It's El Salvador, Guatemala, and Honduras. And despite claims to the contrary, the numbers are increasing, with UACs up 40% in the first 4 months of FY 2019 compared to a year before, according to Customs and Border Protection, and family units up 290%. This has created 3 resource issues for the U.S. Border Patrol, or USBP. First, Border Patrol processing centers were built to accommodate single adult males, not minors or families traveling with children. The recent influx has strained the physical plan available for processing, as groups must be kept separated, especially UACs from unrelated adults. Border Patrol attempts to keep family units together, but space constraints can make that impossible. Second, processing times for family units and UACs from the NTCA are much longer than for Mexican nationals who can be quickly returned across the border. The relationship between purported parents and children must be established, as must legal guardianship, where an adult traveling with the minor is not that minor's parent. Attempts are made to identify family in the United States. In Yuma sector of the Border Patrol, where I traveled late last month, processing times per alien increased from 8 hours in 2005 to, get this, 78 hours in 2018 as a result of these changing demographics. The changing demographics have also increased the cost of care for those migrants. Diapers, formula, food, blankets, and medical care are now staples. Some migrants come into custody sick and injured, some with highly infectious diseases, mumps, measles, resistant tuberculosis. Estimates range as high as $1.2 billion this year alone for Border Patrol to provide such humanitarian aid. Further, the journey from the NTCA to the southwest border is a harrowing one. International smuggling networks from Central America are some of the worst criminal enterprises on the earth. In 2018, the UN put the value of smuggling routes to North America from the southern border in 2014 to 2015 at between $3.7 and $4.2 billion a year. According to Doctors Without Borders, 68.3% of those migrants were subjected to violence, and almost 1/3 of women are sexually abused during that journey. Migrants are at the mercy of smugglers. This does not even account for the physical difficulties of transiting over 1,000 miles, often in hostile desert terrain and the heat without water. Current border policies are intended to deter travel by UACs and families for children because of those hazards. This continues an effort by the Obama administration to dissuade UACs and adults with children from undertaking this dangerous trip. Loopholes in our laws encourage these migrants, however. UACs must be turned over to HHS within 48 hours, usually for release to family in the United States. That's what this hearing's about. This gives an incentive to parents to have their children smuggled into this country by criminals, with the federal government a co-conspirator in the smuggling scheme when it delivers those children. Further, even accompanied children must be released within 20 days, as Mr. Mulligan will tell you. Adult migrants know this and also know that the U.S. attempts to keep families together, giving those migrants an incentive to bring their children with them to hasten their own release. HHS, which places and finds sponsors for UACs in the United States, faces a daunting task. In FY 2018, it kept UACs in one of 100 shelters for an average of 60 days. We discussed that earlier. Most of those UACs are subsequently released to sponsors of the United States, often their own parents, which is confusing because that appears to be contrary to Section 462 of the Homeland Security Act, but we'll discuss that later, I hope. HHS has found suitable sponsors after performing background checks for more than 250,000 UACs as of December 2018. Those UACs are supposed to appear in court, but many don't. In FY 2018, half of all final orders issued for UACs in immigration court, where I served, were in absentia, meaning the UAC did not appear, twice the in absentia rate for removal cases as a whole. While the total number of in absentias is low compared to the total population of UACs, these numbers are still significant. Thank you for your time, and I look forward to your questions.
Thank you very, very much, Mr. Arthur. Let me just have our fifth witness, Dr. Alpha Stewart. Dr. Stewart, you're recognized for 5 minutes for your opening statement.
Thank you. Chairwoman DeLauro, Ranking Member Cole, and distinguished members of the subcommittee, thank you for inviting me to participate in today's hearing. My name is Dr. Alpha Stewart, and my testimony today is on behalf of the American Psychiatric Association, for which I am the current president. The APA was among the first organizations to speak out when it became clear that the zero-tolerance policy would result in widespread separation of children and families. As the physician experts in mental health, we will continue to oppose such family separation policies. From my perspective, as a psychiatrist, the APA's position is grounded in an understanding of the brain science that frames the toxic stress caused by these separations. All children separated from family caregivers will experience stress. And according to the work of the Harvard University Center for the Developing Child, the biology that the adversity takes in any individual child is based on 3 very specific risk factors. First, their age. Younger children are more vulnerable and less able to adapt, usually and primarily because of their underdeveloped brain circuitry. Second, the impact of any previous adversity. The piling on or cumulative effect of these types of experiences and traumas shifts the odds away from there being any successful and positive outcome related to their normal development. And finally, the duration of the separation. It is as if there is a ticking clock, and these things increase over time to the point where the child can no longer adapt, adjust, and be able to tolerate the stress. Children depend on their parents or other trusted adults for their comfort, safety, and support. Any forced separation is highly stressful for children and can cause the lifelong trauma, as well as an increased risk of mental illness, such as depression, anxiety, substance use, post-traumatic stress disorder. As a physician who has dedicated her career to promoting the importance of trauma-informed care, my goal here today is to give you a brief overview of the inherent trauma associated with any forced separation and the potential for lasting negative outcomes. However, for some, the incidence of these traumatic experiences has an even more significant impact on the trajectory of their future life experiences. For children, for example, this impact can be especially profound and usually the result of events over which the child has no control. It is our understanding as physicians and scientists that childhood experiences, either good or bad, can determine one's future health status as it relates to a long-standing body of knowledge called adverse childhood experiences. These common examples include physical, sexual, emotional abuse, neglect, household exposure to a variety of things in parents and caregivers, including incarceration. We also know that children are more susceptible because their brain is still developing. In these situations, although stress may be a common element for all of us in life, when a child is exposed to such chronic stress and trauma, Their underdeveloped brain remains in a very elevated state. And ultimately, this consistent exposure to this heightened stress and trauma changes their emotional, behavioral, and cognitive functioning. We promote for stress trauma-informed care. It shifts the dialogue from what's wrong with you to what has happened to you, and we do this by first realizing that there is, in fact, something called trauma and understanding how we get from that trauma to a path for recovery. We recognize what the signs and symptoms of trauma are. We respond using the full knowledge that we have of trauma-informed care, this evidence-based practice, so that we can integrate this into our policies, procedures, and practices, and we most importantly work to avoid re-traumatizing these children. When we fail to incorporate these concepts into the care that we provide for children who are forcibly separated, we are using an outdated approach to addressing the symptom instead of identifying and addressing the root cause. It is also short-sighted to not embrace the notion that these childhood events are impactful in relation to one's future life experience. The characterization, and I want to take the opportunity here to note that these are facts that are relevant beyond the specific focus for today's hearing. We need to all ensure that health care addressing increasing rates of substance abuse, heightened mental health needs, and criminal justice reform all overlap in the work of this Congress, the administration, an average American, and anyone who seeks to build a better life in this nation. I want to thank you for the opportunity to share these things with you today, and I look forward to answering your questions later.
Thank you all very, very much, and we're really all grateful for your very thoughtful and powerful testimonies. I really appreciate the effort and all of you being here. As in the past, what we will do now is proceed to 5-minute rounds, alternating back and forth by seniority as members were seated at the beginning of the hearing. I just say, and I have to say this to myself over and over again, we want to be respectful of witnesses, try to give you enough time to respond to questions. And I'm told I have to do this housekeeping thing here. To my colleagues, please be sure to turn off your microphone after your remarks. So there we go. Let me just open it up with questions. At the beginning of the hearing, I laid out the timeline of actions taken by the administration to roll back legal protections for children. One of the most egregious actions is the Memorandum of Agreement between ORR and the Department of Homeland Security. You've demonstrated that the MOA has resulted in children spending additional months in federal custody. And yet, as HHS finally acknowledged in December, the MOA has not improved the safety of unaccompanied children. For me, it's a crystal clear example of the administration's effort to keep kids in federal custody instead of following the law, placing them in the least restriction setting possible. They may have a scaled-back fingerprint policy, but my view, until they rescind the entirety of the MOA and the requirement that HHS share any data with DHS, HHS is still acting as an entity of law enforcement. I'm going to read the question. Ms. Brani, can you expand on your remarks about the MOA between ORR and DHS? How did ORR move away from its core mission to care for children and place them with sponsors, instead becoming an extension of ICE? I view this as child abuse, but I'll leave you to speak about that. Ms. Potko, can you talk about the effects on children, specifically effects of being held in federal custody for prolonged periods that you've encountered in your experience working with kids? Mr. Mulligan, if we can get to you, you've recently worked with kids at Homestead. Like to hear about what you found in your conversations with children being held there. Does the Flores settlement apply to children at Homestead? Ms. Browning.
So really quickly, to give my colleagues an opportunity to respond. The Memorandum of Agreement requires continuous sharing of information that children provide in a private setting without any due process on the part of the child or the parent, who may, in the end, bear the consequences of that information sharing. We have seen in a survey that we conducted that it indeed did prevent parents from coming forward, and it also led to some parents withdrawing an application for sponsorship. This drives children to either always stay in our custody for longer, sometimes indefinitely throughout their proceedings because nobody else can come forward, or leads to further, more distant relatives or individuals coming forward to sponsor the child, which also increases risks to that child. And I'll say also that while we have seen that effect, the effect of longer detention or custody, we have not seen a decrease in arrivals, right? It has not served as a deterrent, because what we have found over and over again is that for people who are fleeing violence, deterrent and discouragement in the form of punishment does not work.
Thank you, Chairwoman. I think, there's two things. I think it affects the child's mental and physical health, which, my colleague described so well, but also it really affects the child's ability to move forward with their legal case, right? In some of these facilities, for example, in Tornillo, children were not given attorneys. They didn't have access to attorneys to help represent them in their case, so they couldn't move forward in their case. Prolonged detention has encouraged many children to give valid claims for protection because of detention fatigue. They can't take it being in detention anymore. And for some forms of relief, you need to be in a permanent setting, and so they're not able to access, for example, a form of protection called special immigrant juvenile status for children who've been abused, abandoned, or neglected. So it has significant consequences for their physical health as well as their legal case.
Yeah, so you had two questions. One was what goes on at Homestead. I would like to say that there's some very difficult things that happens there. There's two campuses, a North and South campus. Kids are separated by age, from 17-year-olds on the north side and 13 to 16 on the south side. Siblings are separated and can only see each other once a week for an hour and a half. The schools are in tents, where 20 or 30 classrooms all together in one tent. And kids complain about can't even study because of the noise that goes on. There's so many other things I could share, but I'm running out of time on this. As far as the Flores settlement applying in the Homestead facility, it unequivocally does. The government has said that because it's on federal land, it does not apply, but that it's not exempt simply because of that. Okay, so it does apply here. Absolutely.
With a little bit of time to my colleague, Mr. Roy Ballard, who within the Department of Homeland Security recently bill passed.
Okay, I would just like to point out that in the 2019 Homeland Security bill, in a bipartisan way, we were able to put in a language that prohibits ICE from using information provided by the Office of Refugee Resettlement about sponsors or potential sponsors of unaccompanied children to arrest, detain, or remove those individuals unless that information reveals the individual has a dangerous criminal background. So I just wanted you to be aware that we were able to get that language into our bill, and now it's going to be about oversight.
We also, in the referenced labor HHS bill, and the chair at the time, Mr. Cole, accepted the amendments, or the committee accepted the amendments. One of them was not to separate siblings so that they could not be in the same facility. So if that's continuing to happen, that's something that we ought to follow up on. And with that,
thank you very much, Madam Chair. If I may, Judge Arthur, in your written testimony, you highlight some of the criminal elements and organizations that participate in trafficking and smuggling across our southern border. A series of questions, if you would, just roughly what's the size of the industry, what role do the cartels play, how does immigration policy interact with the criminal element, and do our policies discourage or incentivize the transportation of unaccompanied minors?
Well, let me start with the cost. Secretary Kirstjen Nielsen last year, I believe in May, talked about $500 million, but quite frankly, I think that's a gross underestimation. It was based upon $5,000 per alien from Central America and 100,000 aliens, which just isn't the numbers. As I mentioned, the UN had said it is a $3.7 to $4.2 billion a year industry for people coming from the South. That's a huge amount of money. A lot of this is done by small smuggling groups, and in fact, that puts individual migrants in danger because they don't want to cross onto other territory where migrants could pass through more easily. So when I was in Yuma, they were talking about kids being passed under the river, under accordion wire, because that was the area of the border they controlled. And these kids would come up lacerated and gasping for breath. And there's no cost to the smugglers because of the laws that we have right now. They don't need to enter the United States at all. thanks to Flores, thanks to TVPRA, thanks to the credible fear standard, they don't need to actually bring these folks into the United States. They can just let them off at the border. They don't run the risk of being prosecuted in the United States, and that's what we've seen happen in Yuma. With respect to the criminal element, are some of these groups tied to the cartels? Probably, maybe. But the fact is that when they cross cartel territory, they have to pay. In FY19, Rio Grande sector saw 8,685 UACs. I was down there a couple of years ago, and I was followed around by Mexican Navy in Jeeps. The police are too corrupt to actually be allowed to be around anymore because there are two groups of the Gulf cartel, Los Metros and Los Ciclones, who are fighting for territory down there. You don't cross their territory without paying them. The smugglers have to pay money. That money goes into the pockets of the people who grow the heroin, who make the methamphetamine that flows into the United States, who make the fentanyl that flows into the United States. The smuggling industry cannot be separated from those cartels. FY 2017, most dangerous year in Mexican history because of cartel violence. That's where the money comes from. And the worst part about all this, and this is something I didn't know and I only found out when I went to Yuma, that the payment to these criminals doesn't end once they get to our side of the border. I was told about a system of debt bondage in which these individuals actually have to work for another 2 years and send money to their smugglers in the United States. This is happening in this country because of the smuggling, because of the laws. And yeah, the laws encourage it. Quite frankly, Flores, if you're going to get released after 20 days, you can talk to any Border Patrol agent. They're going to tell you people are bringing their kids because they know they're going to get out. Because of TVPRA and HSA, Homeland Security Act, if you're a parent in the United States and you want your kid, why not pay a smuggler? Because you know that child's going to be delivered to you in the United States. I mean, I'm a father. I want to be united with my child. Dr. Stewart talked exactly about that. So quite frankly, why wouldn't I pay a smuggler to bring my kid to the United States? And there's no cost to the smugglers, as I mentioned.
I may one additional question. Obviously, as you point out in your testimony, we treat Canadians and Mexican nationals differently than we do others. Can you tell me why we do that and what the impact of that is?
I wasn't around when the TVPRA was passed, but with respect to Mexicans, we can quickly return them back across the border after a summary screening. The question becomes why we don't use that summary screening for all children that come to the United States. Because again, there are three bases for getting immigration relief in the United States. You got a job, you got a relative, or you have a humanitarian claim. We can easily screen for those things, take them out of the removal proceedings, not have to worry about any of this time, and actually have an administrative officer do this quickly and easily, but we don't. We insist that they go through removal proceedings. I was a judge. And again, thanks to groups like KIND, we get advocates for those kids, but there's no reason that it can't be done administratively consistent with due process.
Thank you very much. I'm out of time, so I'll yield back, Madam Chair.
Now I'd like to yield time to the ranking member of the Appropriations Committee, Congresswoman Granger.
Thank you all for being here, although your testimony was heartbreaking. You talked about, Mr. Arthur, about the changes in our laws and our rules and how that encourages. Can you go back and talk a little bit about the other thing that's the changes, the Northern Triangle, we know those three countries, that's where by far the majority come from. So the changes in those countries, is that encouraging or discouraging? Do you see any change in the most recent years about that, why they're coming to the United States?
You actually make a variety of good points. And let me just refer to, thank you. Let me just refer, you make a lot of good points. Let me just refer to a couple of them. One of my colleagues actually wrote about a study that was done in Guatemala. This is back in 2017. It's captioned, 91.1% of Guatemalans migrate to the U.S. for economic reasons. Fewer than 1% leave because of violence or gangs. Violence and criminality really hasn't changed terribly in any of these countries, and yet we see an influx of people from these countries coming to the United States. So in reality, you know, we can't really attribute it to that. We talk about push factors and pull factors when we talk about immigration. Pull factors are things like the laws that I discussed with Ranking Member Cole. Push factors are factors in the country like crime or, a desire for better economic condition. By the way, the study was actually done by the International Organization for Migration, not exactly a fairly well-known and nonpartisan organization. With respect to the push factors, are they there? Case-by-case basis, I was a judge, and I take the case that I get before me. But we also get a lot of people coming from Honduras, and we saw these caravans coming from San Pedro Sula, which is a town, I think, in the state of Atlantida, but my knowledge of Honduran states isn't very good. Atlantida is the 26th most dangerous city on the face of the earth, according to a Mexican NGO a couple of years ago. I live in Baltimore, Maryland. Dr. Harris, I think, represents part of Baltimore, Maryland. It's the 21st most dangerous city on the face of the earth, and St. Louis, Missouri is the 14th most dangerous city on the face of the earth. If a Baltimorean were to go to Canada and make an asylum claim based upon harm from the crime, in fact, we had, 12 people shot, 5 killed the other day in the city of Baltimore. And this is commonplace. But if they were to go to Canada and make that claim, they wouldn't be able to. The laws in Mexico, as relate to asylum, are actually more lenient than they are in the United States. But we don't see this population of individuals actually applying in Mexico. Those violence, that crime, that insecurity that they have would probably make them eligible under Mexican law for asylum. But most are not stopping there to apply for asylum. There are 5 factors for asylum relief in the United States: race, religion, nationality, membership in a particular social group, and political opinion. Very strict standards. And again, I've argued thousands of asylum cases. I've heard thousands of asylum cases. At least 1,000 asylum cases. And, again, these are pretty strict rules. And yet, individuals come to the United States, they make these claims based upon crime, based upon violence. And it doesn't really help. Based upon economics, they're not going to be eligible at the end of the day. But if you stay in custody, your case is going to take about 40 days. If you're released from custody, according to the Associated Press, your case is going to take 8 years. 2 years is what you hear about when the case gets scheduled, but the fact is we get numerous continuances. GAO wrote about that last year. Cases get continued. In fact, I can't quite figure out, maybe one of my colleagues could explain this to me. UAC cases are supposed to be expedited, and yet the number of UAC cases that are actually decided is astoundingly low compared to the population. I don't know why that is. Again, with respect to insecurity in these countries, it really hasn't changed a whole lot, but we have seen the numbers increase. We saw them drop in 2017 when Donald Trump was just after his inauguration. In fact, I think 25,000 of the 41,000 we saw in 17 occurred up to January, UACs. And, thereafter it dropped off. And then when the smugglers realized that there was really nothing the Trump administration could do to talk about the laws we discussed, Flores, TV, PRA, Credible Fear, the numbers started to bump back up again. And now people know that, these laws aren't going to apply. We're on track right now for about 60,000 UACs coming into the United States this year, which is actually going to top our number in FY 2016, which was the previous high, as the chairwoman noted previously. So anyway, that's sort of a roundabout way of answering your question.
Thank you very much. Thank you.
Congresswoman Roybal Allard. Recognize.
Yeah, well, I'm going to deviate a little bit from the questions that I had, because all the reports that we have gotten in terms of travel advisories and others is that violence has, in fact, increased in the Northern Triangle. And I just want to give an example about why some people are coming here, and it has nothing to do with loopholes or anything else in our immigration laws. In visiting one of the detention centers, I visited with a gentleman who, his daughter was separated from him, had no idea where she was, and he had been in detention for some time. And we asked him, is knowing what you know now, that you would be held in detention and that your daughter would be taken away from you and you would not even know where she was at, would you still come to the United States? And his response was, Congresswoman, you don't understand. My daughter was threatened with rape and murder if she did not become the girlfriend of this gang member. He says, yes, I would come again because at least I know she's alive. So we can't put all the different reasons that people come to this country into one basket. So with that, I was asked by the American Psychological Association to submit their letter for the record. It talks about the impact of detention on children and need to keep them together. Ms. Barnett, first of all, thank you for your efforts to reunite children who are suffering from these reprehensible policies and practices of this administration. In June of 2018, the President issued an executive order that shifted its immigration policies from family separation to family detention. Family detention facilities, as you know, lack the support and care that children require in crucial developmental years. And as chair of the Homeland Security Subcommittee on Appropriations, I included funding to expand the Family Case Management Program as an alternative to family detention. Although this is outside the jurisdiction of this committee, can you speak to the benefits of the Family Case Management Program and why detention is never an appropriate option for a child?
Thank you. Yes, I've done extensive research and monitoring of family detention centers and thought about this for a long time. And I can tell you that we have struggled in finding humane ways to detain families in an effort to keep them together and have not been able to find them. Inevitably, the detention of children is harmful to their development and their physical and mental health. I could go on for a very long time about the problems of family detention. They parallel what you've heard today about detention and custody of children generally. But what's really frustrating is that there are options. There are alternatives that work. The Family Case Management Program that you mentioned was implemented in under the Obama administration and was very successful by all accounts in ensuring appearance to both court and ICE appointments, but also for removal. So in the period that this program was operational, not very many cases went to the end of their case because of these delays that we all hear about. But in several cases, families, after meeting with attorneys and representatives, decided that they were not going to win their case and actually left voluntarily. 99.8% of the people in that program complied with all of the requirements put on them. And this was a finding consistent with the Office of the Inspector General, ICE's own report on the program, and the contractor's report on the program. So it's a very successful program and much more affordable than detention.
And yet it was ended. Why was it ended?
The Trump administration ended that program in the summer of 2018. They terminated the contract early. They gave no explanation, but it is very much in sync with their then separation under the claim that they had no option if they wanted to ensure appearance.
Mr. Molinar.
Thank you, Madam. Thank you, Madam Chair, and I appreciate the witnesses' presentation this morning. And you know, it's clear to me that from the testimony we've heard, we've got a very untenable situation where men, women, and children are making a dangerous journey to the United States, just from start to finish. And you know, there's a number of circumstances, and I think you've identified a lot of those, and some are escaping dangerous situations in their countries. Some are hoping to join family members here in this country, but all are coming because in this country we have freedom, we've got the rule of law, and it's made our country a desired location. And you know, right now our nation's success and the prospect of being here has also attracted people who would do harm here, have created a whole market for people who are doing harm to the victims who are coming here. And, you know, the cartel violence, and I'm horrified to hear these stories of families affected by that. That violence can also fall on this side of the border. And the drugs that are coming across, the heroin, meth, fentanyl, I mean, record numbers. And I'm hearing more and more about that in my own district in Michigan, in the 4th Congressional Districts. Over 100 people die across the country every day from opioid overdoses. And you know, it's coming through the ports of entry, through the miles of border between those ports. And for the women and children, it's very clear that who make that journey, it's a perilous trip. And it involves drug smugglers, human traffickers, and those who are harming women. You know, the 30% number in the journey is incredible. You know, I'm not an expert in our legal process of coming to this country, but my understanding is, you know, we would want people to come to the ports of entry to come to the country legally, especially when it comes to asylum claims. You know, I think in this room we could agree that it's important to have a secure border. At the same time, parents who break the law and enter the country illegally, I think it makes sense that they would remain with their children while the judicial system works. And we've heard a lot about that today, although I do recognize that it's difficult to, with certainty, identify that they are indeed safe, and even in that situation. You know, my hope is that we can use our resources to make the border a safer place for people coming here, protect the American people from drugs and violence, and use best available technology. You know, I've been talking to border agents in my office. You know, they need the cameras and sensors, more border agents, and they are taxed in terms of their resources at the border. And I do believe that we need a physical barrier. I don't see how anyone could say that that doesn't make sense. But it's really unfortunate that these larger solutions aren't even being discussed. It's like people are making their point on some issue, and unfortunately the issue doesn't get solved on a comprehensive way. And so my hope is that we could move forward on this, and this committee could be part of that. My grandfather came to this country as an immigrant, was a laborer, farm laborer across the country, and then saved up money to buy a farm. And that's what I hope, you know, other people who would want to come, but he came legally. And I think we need to improve our system to encourage legal immigration, because this truly is a great country, and we want to make it a welcoming country for people. I am very concerned, though, that we are, you know, we've critiqued different policies. One of the policies I think is as disastrous as a policy that creates false hope for people, that tells people if you can just get to the border, you're going to be here. And it's creating these caravans and people who are harmed along the way and even at our border. And somehow we need to send a message, whether it's, you know, working with Northern Triangle countries to improve the situation there, or somehow work with Mexico. But I just think this is an untenable situation, and I have learned a lot today, and so I appreciate your testimony. I don't have a specific question, but I very much appreciate the testimony today. Thank you, Madam Chair.
Thank you very much, Mr. Molinar. Mr. Pocan.
Thank you very much, Madam Chair, and thank you to all the witnesses for being here. I do have to admit I am disappointed that ORR is not here. I understand they were invited, and they said they couldn't prepare it in time. I am looking forward to it. I'd like them to have heard from the witnesses here. I think it would have been really powerful for them to have heard from that. Mr. Mulligan, one of the things you said I really appreciated was, as you mentioned, many of us have tried to go down to the border. You said a trip to the border isn't going to give us the full knowledge we need, and I totally acknowledge that. I think we visited 4 facilities when we were down there. One of them was the Super Walmart Detention Center that, you know, 1,500 kids. They get out 2 hours a day out in the sunlight. The sleeping area they had was 6 by 10 that's allocated for them. A Supermax prison cell is 8 by 12. You know, when you're if you lose your parents in a mall, it's traumatic. If you're there for days or weeks or months, you can fully imagine the type of trauma that's created in a facility like that. We talked to the people. They had just hired 860, I think, new staff for another facility, but they couldn't hire 90 mental health staff they needed that were bilingual for the current facility, and that was part of the experience. But you know, clearly seeing that, it's not a situation that's going to provide any kind of decent environment for the children who are there. And again, we're doing it to ourselves by doing that. And I have to admit, I thought it was a rather strange and false comparison to say the conditions in Baltimore or St. Louis are worse than these countries. Quite honestly, Mr. Arthur, I thought that was a disservice to your testimony. I enjoyed much of your testimony, but that was so bizarre and so not based in reality. I've been to El Salvador and been to these neighborhoods. You know, to try to compare it, you know, I don't think did you a great service. I think my question specifically would be for folks to think about if ORR was here, since you are the professionals who deal with this the most, what would be the question you would have for them? Whether it be a question about policy, a specific case you want to highlight, whatever that specific question is, when they get here, I'll be glad to ask your questions because you're the ones dealing with this every single day. And I would just be curious what questions you have. Just while you're thinking about it, I will add, you know, one of the problems I have with the MOA and why I'm glad that we got the language that we got in there. I've been waiting 138 days on a Freedom of Information Act request with ICE. They won't even tell me about 79 people that were arrested in my district, what they were arrested for. They released 4 of the names of the 83. They were people that should be deported. But I know of people in my district that have done nothing that supposedly is the criminal element they're going after that were apprehended on that. So I can certainly understand the situation, why that would be a deterrent for families to want to even go in, knowing how ICE is operating under this president. But let's start with you, Mr. Mulligan. What would the question that you would like to ask ORR that I can ask for you?
Well, I appreciate you bringing it back to ORR because I think we've sort of lost track of what we're talking about here. This is the Committee on the Health and Human Services. It has nothing to do with building a wall with drug smugglers. There's nothing about that HHS has any jurisdiction over. And so while we're throwing out these red flags about those issues, we're losing sight of the fact that there is over 10,000, 12,000 children detained in this country right now, many of them in facilities. I mean, the Homestead facility is an old Job Corps building that has just been refurbished as a warehouse for kids. Like I said in my testimony, this is about human dignity of the children.
So I do appreciate that, and thank you for bringing us back to that, but I got about 20 seconds a person if I can.
Sorry, so the question I would ask for ORR is, why can we not reunite someone with a sponsor, and why are we holding these children in these conditions?
Okay. Next, Ms. Butkel.
Thank you. I would ask them about prioritizing the resources that you all have given them. You know, they're spending a lot of money on these influx facilities to hold children for very long periods of time. And how can they be better prioritizing how they're spending their resources? You know, reducing detention times, using cheaper facilities, and increasing more services and post-release services for the children.
Great, thank you. Ms. Brownie?
Similarly to that, and regarding prioritization of resources, I would ask them about efforts to license and get into compliance the facilities that are not, and why it's taking so long, why an emergency influx facility is open for over a year, for example, and what is being done about post-release services and legal services for children that we know are really critical in both ensuring their appearance for court procedures later and their general well-being.
Great, thank you. Mr. Arthur, you got enough time before, so let me go over to Ms. Stewart since I have 3 seconds.
Well, as the person on the panel probably with the least understanding of what their official role is in this process, I cannot give you a specific question, but what I can ask you to think about asking is related to the obvious trauma that children experience in these settings. How trauma-informed is everything that they plan in terms of services and supports on the reunification aspects, on the what's happening while they're here with us aspects, what kind of staffing, training for that staffing, other resources, what kind of clinical care is available for these children as they are going through whatever their process is.
Thank you all very much. Appreciate it.
Mr. Harris.
Thank you very much, and thank you, Madam Chair, for calling this hearing. Let me just start with just a question about the Women's Refugee Commission. Are you aware that it opposes America's efforts to cut funding to Palestinian agencies that support the rewarding of Palestinian terrorists that kill Jewish children with lifelong pensions and their families get paid for that? Are you aware that your commission does that?
That is not part of the area that I'm responsible for, so.
Okay. So do you disagree with the commission on that, or do you think that the United States should be funding Palestinian terrorists who kill children just because they're Jewish?
It's not my area of responsibility and not relevant.
Again, I just find it interesting that you come and testify on children's, the benefit of children, and here you are, with an agency that actually opposes U.S. efforts to stop Palestinians from paying their terrorists who kill children. I just don't get it. Anyway, Judge Arthur, and I do want you to comment on Section 462, because I know you said we might bring it up later, but the unaccompanied children is what bothers me, because unaccompanied children, by definition, are not separated by us at the border anywhere. I mean, the bottom line is they come in unaccompanied, and I assume some of them are sent by a parent to the United States, presumably for a better life, maybe to live with relatives, but it seems like that our policy should be actually to discourage as much as we can unaccompanied children coming to our border by whatever means necessary in order to keep them united with their families that they're leaving. Am I missing something here?
A couple good points there, Dr. Harris. One is with respect to who pays for them. If we're talking about children of tender years, and I think about 72% of these people are between 15 and 17 of the UACs, I could pretty safely assume that they're not paying for the journey themselves. So logically, someone in the United States is, and all the anecdotal information that I've ever seen has indicated that that's exactly what's happening, that the parents are, or the relatives are paying the money to bring these people to the United States. There was a big New York Times article about that a few months ago that talked about an individual and his uncle. But with respect to that, and this sort of goes to the danger that these people that, are faced in these countries. Imagine, you're a father, I'm a father, that we, had a situation so perilous where we lived that we had to escape it. Would we leave our kids behind? I mean, that sort of would, indicate to you, it says in the book of Luke, what, father, if asked for a fish by his son, would give him a snake, or if asked for an egg, would give a scorpion. If the danger is really that keen, logically, you would bring the child with you, or alternatively, you would not make the journey yourself. And so, it sort of does go to the danger that they face. With respect to, again, money flows from these individuals into the pockets of, the smuggling groups, the cartels. It just goes to fund more crime.
Sure. So, because Dr. Stewart did mention, and it's good to be in a room with another physician, did mention, the idea of how traumatic a separation is, and an unaccompanied child has always been separated from their adult family. Am I correct? That's the definition of a UAC, right?
Absolutely. And,
right. So our policy objective should be to not encourage separations, I imagine, right? Because it's traumatic. So we should pursue policies by whatever means to discourage, and apparently we didn't do that, right? Because we had a surge of unaccompanied children. So I would imagine that that's true. And I'm just going to give you the last minute, because you said something about Section 462. You hope we bring it up, so this is your opportunity.
Thank you so much. I was actually in the room when we passed this, and I really don't even know why ORR was given the responsibility. There wasn't a whole lot of debate. 6 U.S.C. 279 G2 defines unaccompanied alien child as a person not lawfully present in the United States, not 18 years of age, with respect to whom there is no parent or legal guardian in the United States, or no parent or legal guardian in the United States is available to provide care and physical custody. But we know that 58% of these kids are reunited with parents and legal guardians. So my question becomes...
Let me just interrupt you there for a second. We know that that's the claim made, because I understand we can't even test the families to see, and look, as a doctor, I know, you do a swab, 2 days you got test of whether that person really is a relative or not. My understanding is we can't even test for that.
Well, one of the most egregious things is we don't fingerprint children under the age of 14 by policy. So quite frankly, you could recycle the same child over and over again if you want to get to the United States and be released as a family member. I don't really even know why we have that policy.
Thank you very much. I yield back.
I just might add that the point here is that with this this hearing is the fact that by law we take in unaccompanied children. We have to deal with that, and it is about what Mr. Mulligan said, the conditions that these children are being held in, and whether or not we believe that those conditions are, that we condone, that we believe are the right way to treat children. It is not about the separation. The separation only added to the list of unaccompanied children by virtue of the policies of this administration. Let's keep our eyes on the focus on the jurisdiction of this committee, which is to protect the welfare, the child welfare of these children that we take in as unaccompanied. No one is talking about immigration law, immigration policy, as Mr. Mulligan pointed out, but we are charged with taking care of these children. Congresswoman Bonnie Watson-Coleman.
Thank you, Madam Chairman, and thank you for having this hearing. And let me associate myself with what you said about this being child abuse, and that's exactly what it is. A major concern of mine has been the use of private prisons in our criminal justice system, where private companies make money performing the public function of incarcerating people, and I've introduced legislation to end that practice. So it's even more horrific that there are for-profit companies getting rich off of detaining immigrant children, and that's exactly what's happening in Homestead, where Comprehensive Health Services, Inc. charges $750 a day to detain children, which is triple the cost of the typical nonprofit facilities that HHS normally uses, and I'm not even speaking to the conditions at the HHS facilities. $750 a day sounds more like the cost of a luxury hotel rather than the detention camp you described, Mr. Mulligan. In fact, they make so much money, their parent company cited this administration's immigration policies as reason for, quote unquote, significant growth. Mr. Mulligan, first I want to thank you for the work that you are doing trying to protect these children. From your visit to the Homestead facility, do you see any evidence that this tremendous amount of money we are spending on this for-profit facility is really going to ensure the best care of these children rather than just making stakeholders rich? And are you also aware of the article that came out about the 4,500 and some sexual abuse allegations that these children have apparently been exposed to? You put your mic on.
Thank you for your question, Congresswoman. To the first question, in terms of my visit to Homestead, because it's a temporary facility and it was an old Job Corps site, there was a cost of millions of dollars to do build-outs, to build tents. You see these huge air conditioning units pumping in air conditioning relentlessly. They've told me, and I think the physicians could answer this better, but they said cold temperatures, really cold temperatures, stops the spread of germs or bacteria, so the kids are freezing all day. But apparently they're not getting sick, I guess. I don't know. I do not see that money going to the kids. I see it going to making what was a Job Corps office building into a place to house children temporarily, but it's not temporary anymore. And I'm sorry.
Because Job Corps tend to be residential in nature, too.
One half of the campus is residential, and the other half is just the office buildings, where the 17-year-olds were housed is office buildings. And that has required build-outs for bathrooms, showers, everything. And I'm sorry, your second question again was?
Yeah, there was an article in the news just last night about thousands of allegations of sexual misconduct and sexual abuse of the children that are detained. And I think it highlighted Homestead.
Yes, we've heard of allegations for Homestead as well. We haven't.
Well, I need to know who. It's very important that we do have the government officials here to talk to us about what's happening, what they're doing about that. And Dr. Stewart, you discussed how traumatizing family separation can be for these kids. Can you further discuss the importance of proper aftercare after they've been separated and how the conditions at Homestead and Mr. Mulligan described exacerbates children's trauma. Would you turn your mic on? Thank you.
Thank you for that question, Ms. Watson-Coleman. I think the most important thing is what I suggested earlier, that any facility where children are being housed who have been through these kinds of traumas has to be trauma-informed in the care and support that they provide. That means up and down the chain, from the leadership understanding how not to create policies and practices that re-traumatize, to the staff being trained in understanding and being aware of how to recognize the symptoms, how to address those problems, how to understand behaviors that are trauma-related but that express themselves in aggression, fighting, reckless behaviors of some kind, challenges to authority. These are manifestations of children who are expressing their traumatic illness.
Excuse me, but does anyone know whether or not there's that kind of personnel on staff all the time at Homestead?
So what we were told was that there's 19 clinicians, or sorry, 19 children for every one clinician. And to speak with a clinician, a mental health person, you're in a room with 20 other people at the same time. And so so you're not sharing your intimate stories, your traumas in a safe space. You're sharing it in a room with a small room with very basic cubicles. The clinicians have cubicles where someone's sitting next to them and they're conducting their mental health intakes with them in that way.
There's so much more we need to know.
Congressman Barbara Lee.
Thank you very much. I want to thank all of you for being here, and just have to say, first of all, this is the most despicable policy of this administration and any administration that I've seen in a long time. Secondly, I'm reminded that this is the 400th year of the first slave ships coming to this country from Africa, where children were snatched from their parents, only to learn of generational DNA changes which are still with us in many ways. And so this is a violation of children's human rights. It's child abuse, it's kidnapping, and it's downright morally wrong. And it's something that, as a mother and a grandmother, that it's something that it's hard to even fathom, and being an African American. And so I'm a clinical social worker by profession, Dr. Stewart. So I wanted to drill down just a little bit about this. First of all, we're learning of the sexual assault of these children and the trauma that this adds to the trauma that they've experienced. Secondly, I want to ask you, just in terms of treatment modalities, I mean, you know, an intake 1 or 2 sessions, just as a clinician, I know this is going to take a heck of a long time for these children to recover, if ever. And so I wanted to ask you, kind of with trauma-informed care, what's the treatment process? Also, how does anger fit into this? Because I swear, I'm concerned about these kids growing up being angry at the United States for doing what they did, for us doing what we have done to them. And so how does anger fit into this, and what does a treatment modality look like in terms of trauma-informed care? Because this is really something that, it's another stain on this country. Someone said it was a stain, it's another stain. And so we have to get to the bottom of this and stop it as soon as we can and take care of these kids and change these policies.
Well, thank you for that question, Ms. Lee. Let me start with trauma. It is a specialized area of treatment. Not every mental health professional treats trauma or is trained to recognize and provide treatment for trauma, and not every trauma treatment specialist has the level of criteria of qualifications that I do as a psychiatrist. The National Center for the Traumatic Stress Network trains hundreds of clinicians and other people around the country specifically to work with children and adults who have been exposed to some level of trauma. What we're talking about in terms of trauma-informed care can run the gamut. It can be along a continuum. There are evidence-based treatments like trauma-focused cognitive behavioral therapy, which is very structured, 12 weeks of very structured, clearly defined, evidence-based well-researched and studied and validated across multiple populations and with multiple kinds of exposure to trauma that is very effective in working with children of a certain age. There are trauma-informed treatments that have more effectiveness with younger populations. There are treatments that are available to families. The bottom line is that there are a range of treatments that can be made available depending on the need, depending on the severity, depending on the willingness and responsiveness of the individual or the family to engaging in those treatments with the treating professional. The anger that you describe is very often a manifestation of how that trauma in the young child especially can be expressed. Children, while they are adaptive and resilient, do reach a point where enough has gone too far. And when they are at that point, they no longer have the neurological capacity to continue to take in the trauma. It has to come out. It has to be expressed. And what we see often, and I'm assuming, I've not made a visit to any of the facilities, but what I would assume is that some of what has been described as aggressive behavior, hostile acting out, crying and being uncontrollably able to stop that and not being able to be comforted even when comfort might be around has to do with the level of trauma that they've been exposed to and the fact that there is nowhere to take it. They have no one to comfort them that they are familiar with and can trust. They don't recognize what's going on. Everything from sights and sounds and smells and people approaching you and how they talk can trigger these kinds of behaviors. These are normal responses to abnormal situations.
God knows how they're going to react as adults.
What we know about trauma, and especially about adverse childhood experiences, is that as an adult, in fact, the original work to study this was done decades ago by two doctors, Vince Folletti at Kaiser Permanente and Bob Anda at the CDC, who were looking at adults who were recounting experiences from their childhood and began to put the pieces together and say, there's a connection here between what happened then and what's going on now. And they connected those things to chronic medical problems, to mental illness, to domestic violence, to a range of things. So we will be able to see the manifestations of untreated, unrecognized, and untreated adverse childhood events, serious, intense trauma in these children as they age.
Congresswoman Clark.
Thank you, Madam Chairwoman, and thank you to the panel for coming today. Mr. Mulligan, I'd like to start with just a baseline legal question. Is it a crime to enter this country seeking asylum?
No.
Anywhere that you enter seeking asylum?
Well, I believe the Trump administration tried to make it a crime for a while and not allow you to apply for asylum if you were not applying at a point of entry, but that has been an injunction by the courts.
That's right. So currently, it is not a crime to enter this country seeking asylum.
That's correct.
Are you aware that children at Homestead who are staying in this influx center, when they turn 18, are being shackled and sent to federal prison?
Yes, as we were told, that's their birthday present.
And that this applies to both, girls, boys, turn 18, you're sent to federal prison. Why would that be if there is no crime of illegally entering this country?
There is, in my understanding, that there's there's no transition facility. When someone turns 18, they're considered an adult under the law, and so they go to an ICE detention center.
Dr. Stewart, you were just talking about trauma-informed care, and I know that you are not ORR, but do you have any sense of the quality of counseling, given the expertise that is needed to treat these children for the trauma that we have inflicted upon them at Homestead or throughout the ORR system?
I have no specific and direct knowledge, only what has been reported from people who've made visits, who the American Academy of Pediatrics, and who talked about that. The original person who wrote one of the letters identifying the challenges facing these children is a psychiatrist in Louisiana. and she identified some of the problems with the kinds of services that were being provided, but I have no personal knowledge of that.
Do you happen to know if ORR in the past was able to manage the unaccompanied children through the use of nonprofits? Has it always been such a private, heavily private industry?
I can say that generally it's been operated by nonprofit or not-for-profit institutions, but the focus has been on locating facilities that are shelter-like, home-like environments. In the past, that was the focus, and I think what we've really shifted to now is these large institutional settings that, as you heard, have very large profit margins and are not focused on the well-being of children and are not licensed. I'm very concerned about the licensing, including that some of these facilities, ORR does not consider them permanent, and therefore they don't even fall under the requirement for Prison Rape Elimination Act audits, which goes to this issue of safety.
And not only is there a startling number of sexual assaults reported from staff members, but also child-on-child assaults, which goes to your very point in the need for licensing and regulation. Do you have any understanding from ORR what they are doing to improve the background checks of the staff at these facilities?
Well, we've talked with people in the FBI, and apparently background checks do not take 1 month or 2 months or 3 months as they're taking now. And when we visited the Homestead facility, they actually conducted background checks on us before we could talk with the kids, and they finished that within the same morning. So I don't know what ORR is doing in terms of why the background checks take so long.
Yeah. Words fail me at how we are failing these children and these families. And I do want to ask you just briefly, with the Flores decision, 1997 has been around. What was the point of that decision? Was it to make sure that children were cared for and released as quickly as possible to family members?
To be clear, it's not a decision, it's an agreement between the federal government and children detained. So the federal government agreed to this. It's not like a court enforced them to it. The federal government entered into this contract and said, we will treat children in this way. And there's been various court decisions interpreting it since then, but it's still a binding settlement agreement on the federal government.
And do you believe that this agreement is responsible for increase in human and drug trafficking across our southern border?
I don't. I don't think we can blame legal protections for migration. I mean, if we go down this line, at some point we're going to be saying the Constitution is attracting people to our country, so let's not apply that to undocumented immigrants. This is a slippery slope, and I hope we don't fall down that.
Thank you. Thank you, Madam Chairwoman.
Thank you very much. I'm going to try to move quickly through some questions. I just want to mention to you that, Dr. Stewart, that I've been pleased. I really, the National Child Traumatic Stress Network is really fantastic. What we did in the last bill was $4 million for the fund specifically to work with children who were separated from their families. And we've tried to increase the funding in that program every year, and we're going to continue to try to do that this time. So thank you very, very much for your comments and your testimony in this area. I got to tell my friends at Yale Child Study, my God, you guys are great. I want to just a couple of things. Ms. Bronte, Mr. Arthur discussed the dangers of traveling to the U.S. border. Your testimony, you noted the administration's termination of the Central American Minors Program. Was this an opportunity to apply for asylum without undergoing a dangerous trip to the border? Just very briefly, what was the Central American Minors Program?
So the Central American Minors Program allowed children to apply for relief for entry into the United States from outside of the United States and from their region, so from their home country or close by. And the point of it was exactly to prevent children from having to make this dangerous journey. Because one thing that has not come up today is that there is really there are very few options for children who are fleeing violence to get here.
Is there more violence now in some of these countries? Mr.
There is.
Lasser
We have
doesn't think
seen,
so. You
since
think so.
2012, the Women's Refugee Commission has been looking at this issue, and we have found increases in violence in each of those countries that are very much in sync with the increased arrivals.
Well, we know they did away with case management. They did away now with Central American Minors Program. So opportunities and able to alleviate and relieve the system, they've put aside because the issue is about using this as of enforcement. That is it. So you take away and strip away all of the opportunities to create a more efficient way of proceeding, which was being done by the past administration, but to make it much more difficult. Mr. Mulligan, a couple questions here. Is the Trump administration using influx shelters to get around the 20-day maximum mandated in Flores? What other ways do the administration disregarding the protections mandated in the Flores settlement? Should we codify Flores?
Several questions, Congresswoman. First, yes, we've heard several arguments. There is an exception in the Flores settlement agreement for influx or emergency facilities, but there is no exception, importantly, as I say in my written testimony, for self-created emergencies or fabricated influxes. And so they're using the homestead facility as a way to get around the Flores settlement and saying it doesn't apply to that facility. It absolutely does. And I'm sorry, your second question was?
Does it appear the administration is disregarding the protections mandated in Flores?
Absolutely. And it's not just this administration, but since 2000, we filed a motion to enforce in 2015, 2017, 2018, and
I frankly don't care what administration was if we are obligated to abide by Flores.
You're absolutely, the federal government it's a contract no matter what President Trump as an individual does with contracts. The federal government does abide by contracts, and it needs to.
Should we codify Flores?
The Flores settlement agreement has a stipulation that it will go out of force once there are regulations that are promulgated that are consistent with the letter and the spirit of Flores. The Trump administration last year tried to implement regulations on the Flores settlement agreement that had nothing to do with the Flores settlement agreement. So it should be codified, but with the spirit and letter of the law as it is.
Okay. Let me then just ask Ms. Podko, just briefly, the appearance rates of unaccompanied children who are placed with sponsors, do most of them show up for the hearings?
When children are represented by attorneys, they overwhelmingly are showing up because the attorneys can explain to them what are the requirements, what is it that they have to do. And let me be clear, a question came up about, are the courts adjudicating their claims? Are they not showing up? The majority of children are applying for humanitarian protection, and those applications go to USCIS. So the courts are kind of managing the cases to maintain and see what's going on with the children, but it's USCIS who's ultimately oftentimes adjudicating the child's claim for protection.
Do children, I mean, you've heard the testimony here. There's a suggestion that children choose to leave their homes and travel to the U.S. because our policies are too lenient. Are our policies too lenient here? Why are people, being driven to do what they do?
The kids that I've talked to, they know how dangerous the journey is. They know they could die on the journey. They know when they get here, they're going to be thrown in what's called an icebox. They know they're going to be
Helena, which we've all visited. Right. Some of us have visited, and it is freezing cold.
Right. I mean, some of these families and these children knew they were going to be torn away from their parents, and they're still coming. So if the risk of death, in the journey is not enough to stop them, no deterrence that we can do is going to be worse than what a lot of them are facing in their home country.
Thank you. Congressman Cole.
Thank you very much, Madam Chairman, and I want to thank all of you for your testimony, too. Judge Arthur, since, you've litigated a lot of these cases, does somebody automatically have the right to come to the United States for economic advancement?
No, and actually the question was raised before whether illegal entry into the United States is a crime. Illegal entry into the United States actually is a crime under Section 275A of the Immigration and Nationality Act. It's a misdemeanor punishable for up to 6 months. So, no, you don't.
Okay, and would you automatically have the right to come to the country for family reunification purposes?
If you get a lawful visa, and we do have a very generous lawful visa program, more than 1 million people enter the United States as immediate relatives every year, you can take advantage of that and come to the United States. Also, with respect to the Central American Minors Program, which I think was raised before, I believe that President Trump had offered to reinstate the Central American Minors Program in exchange for funding for barriers along the border. But in fact, I believe this committee rejected that request.
And I'm not casting aspersions on anybody here, but if I wanted to come to the United States, I'd probably try to figure out what are the ways that legally they're going to accept me, as opposed to if I have a motive that's different, I don't think I'm going to volunteer that motive and say I'm really here. So this idea that these statistics actually reflect what the motive is, I think is pretty flimsy idea. In your experience, you mentioned you'd litigated 1,000 of these cases. Are people always honest with why they say they're coming to the United States, or do they try and tailor testimony toward things that they think will give them the legal right of entry?
Again, the plural of anecdote is not data, but I can tell you right now, Mr. Cole, that in every case that I ever decided, I would make a credibility determination. In many, if not the majority of those cases, that was an adverse credibility determination. I have no recollection of any of those adverse credibility determinations being overturned by another court.
Okay. Let me ask this, and I'll address this more widely to the group. This isn't a new problem, and we did deal with this surge before, and then as has been suggested, the demographics of the population have changed. That's made it difficult to have the appropriate facilities. The last administration confronted this, and in full disclosure, I worked with Secretary Burwell to try and make sure she had the resources to deal with this. But did they leave anything in the way of permanent facilities, permanent infrastructure, or did they pretty much, as we've seen in the past, create, and I had one of these in my district, create a center for a period of time, and then when the flow came down because people had either been placed and we were not paid, just let it all collapse back down again. So we're in the position of sort of constantly reinventing the wheel. Has that been our experience as a country?
It's hard for me to know exactly. I mean, I will say that ORR has gradually, they have certainly tried to tried to increase the number of facilities, and they do have more facilities in place now than they used to. But they did open and close some of these large influx facilities. There were several that were open in 2012.
Yeah, again, and I'm not throwing rocks at the last administration. I think this actually gets back to a point that Judge Arthur made. The demographics of this population have changed, and that's straining the physical capacity. It's straining the personnel that you would need. One of our great problems in mental health is we just don't have enough people, period. I mean, the idea that we would have these kinds of people available in sufficient numbers here, particularly on an on-off kind of basis, stuff. And, I think it was a telling point when you said at the beginning of the Trump administration, the flow came down, and largely because you thought you couldn't get in, probably, I would assume. And then once it became evident, no, the structures are still in place that make it, I wouldn't say attractive to run this risk, because I don't think it's attractive for anybody to run the kind of risk of a 2,000-mile journey. I mean, people don't undertake that sort of thing lightly any more than, 300 years ago they undertook lightly traveling across an ocean and coming to the United States. That's a big life gamble for somebody, and you have to feel like there's some big upside at the other end because you're running a risk. So, given that, I mean, it seems to me, what are the sorts of things we can do? Because we know it's risky that would discourage that. It seems to me, Madam Chairman, and that's beyond our jurisdiction. I'm certainly not critical of that. But a lot of this gets back to stabilization inside these countries, which I know my friend Ms. Granger worked on, and frankly, which we tried to address recently in the spending package, where we put a lot more money again into these three particular countries. Yeah. Yeah.
Mr. Cole, one thing that I would like to correct, before I think when you were asking me, I said that 2016 was a high year for UACs. It was actually 2014, 68,631. We're on track for about 60,000 this year, but as this graph will show you, we're not actually in prime travel season yet, so I can't guarantee you that we're not going to see many more people come to the United States.
I'll close just with a quick comment, just because I remember, again, having this discussion with Secretary Burwell, and literally each month them wondering how many people were coming in. They don't have a very reliable way to predict that. And so it's extremely difficult for any administration to plan, to have the people in place and the resources. Thank you for your indulgence, Madam Chairman.
Roybal Allard.
Just very quickly, Ms. Putko, what challenge do you and your colleagues face when trying to unify a separated child? And what would you recommend to make tracking of children and their families more accurate and efficient?
Jennifer, go ahead.
All right, specifically for families who've been separated by CBP?
Yes, because there's been some reports that
Yeah.
they've lost track of where the children are and where the parents
Right.
are.
And, the government is reporting that they've made changes to improve the tracking of the separations. I can tell you just a few weeks ago, my colleague met a child who had been separated from his father, and that was not indicated in any of the paperwork that the government gave us, and the attorney was not notified. The only way we found out was by talking to the child. So I think what we need to do, and suggestions that you have offered before in the past of having child welfare professionals in CBP facilities helping decide which children, if a child ever needs to be separated, make sure that it's a child welfare professional who's making that decision, and that tracking starts in that moment for the reasons why. So both the child and their attorney can understand, but also the parent, because sometimes, the decision was made in error, and the parent should have the right to challenge that so they can reunify with their child as quickly as possible.
So would you recommend something along the lines of a shareable family unit tracking number?
Absolutely. There should be a family unit tracking number that follows both the child and the parent. And I would suggest that that happens not only just when a child is separated from their parent, but from any family member that they might be traveling with, right? So you could have a child who's been cared for by a grandparent their entire life. And if they're being separated at the border because they don't fall under the definition of family, we need to know, and the child's attorney is going to need to know that. It's often the adult who's going to have the information about the child's case, have contact phone numbers, have documents that are going to be necessary. And so it's really important for the child to always be able to find and have contact with any family member that they've been separated from at the border.
I guess they would also be helpful. As my understanding, there is no standardized protocols or systems between the different agencies that come in contact with these children. So
Exactly. Exactly. Yes. Thank you.
And if I can just add finally, that they also really need to look at the final piece of that on potential reunification after investigating what the reasons for the separation were, right? There was a story that came out about a mother who was separated from her infant child because they thought a criminal conviction had come up on her case. It turned out that was a mistake. She had no criminal conviction. And nothing was ever done to rectify that situation. If you really are concerned about the welfare of the children, you should be following up on, how to reunify them ultimately or resolve the situation.
Because I believe there have been several reports about ORR grantees reporting errors and referrals from CBP and ORR, including incorrect gender, age discrepancies. So that also adds to the issue of not being able to unify.
Will the gentlelady yield for 30 seconds? Are we still separating children and
Yes.
rendering them? We are still separating children, rendering them unaccompanied children, and adding to the system. So even though there's been a court order that says no, it is still happening in contravention of the court order.
Yes. Not only is it still happening, but in most cases we don't know why it's happening.
That was going to be my question. What reasons is DHS giving?
Sometimes we'll get there'll be vague indications in the file about why. They may say there's a criminal history, but we don't know what that means. Does that mean that was a forged check and that parent poses no danger to the child? Is it a reason because they have a concern about the veracity of the relationship between the child and parent? That is very important information. So whenever a separation happens, we need to know why, and all the information has to go to all parties.
Is it mostly on immigration things, violation of immigration?
We don't know.
You don't know. On this piece, before we now know that there was a separation happening in 2017. Again, rendering. I want to focus on the jurisdiction of this committee, which is unaccompanied children. However, there has been no accounting. There are thousands of children at the IG, this is not me, that we listen to, thousands of children that were came into a custody, if you will. Some were discharged, but we have no idea who was accompanied and who was separated. And we may, well, we're going to get a full accounting of that effort. Thank you. Mr. Harris.
Thank you. Thank you very much, Madam Chair. Mr. Mulligan, I guess you're an attorney. I'm just curious what you said, what President Trump does with contracts. Do you know something we don't know about contracts?
I think that's the hearing downstairs,
right, or just what you read in the fake news. I don't understand. I mean, you're an attorney.
Right.
I would think you'd speak more carefully than that, unless you have personal knowledge of contracts. Do you have personal knowledge of contracts the President has had that you think may have been violated?
Just what's reported in the news.
Okay, that's what I thought. Okay. Judge Arthur, we got a real problem in Maryland. It's called MS-13. As you know, we're the second most active state for MS-13, only behind California, whose population is, my God, I don't know, 10 times Maryland, whatever it is, a lot more. When you have an unaccompanied child come across, and I mean the ones who cross the border as UACs, not the ones who become, through determinate, through the fact that something happens to their UAC, but the ones who cross, I probably wouldn't be good at guessing age at a carnival, but I've seen some pictures of people who come across claiming they're like 15, 16, may not really be fit. I imagine some come without any papers, no proof. I mean, look, if I were going to cross the border illegally as an MS-13 member, I sure wouldn't bring my ID card. So it brings up two things. One is, how difficult is it to determine, because I really don't want MS-13 members come more in Maryland. We have plenty. Maybe some other states will take them. God bless them. I don't want any more in Maryland. It's got to be hard to tell who they are, and I'd like you to address how difficult it is to determine who is actually a criminal, who is not, who's coming here for nefarious persons, who is not, and who is not a subject of human trafficking, because that's another thing I'm worried about. And I just want you to address very briefly, the allegation that somehow we're shackling people when they turn 18 with no with no basis, because I'm not sure that anybody does that. But what's the basis for someone turning 18 and in fact becoming subject to a different set of laws that do require detainment?
Let me start at the end. The TVPRA and Homeland Security Act both actually talk about minors under the age of 18, and for that reason, you actually enter into the adult system when you turn 18. And so, a different set of laws applies to you, simply. With respect...
Excuse me, and that's not just true with immigration, right? I mean, when you turn 18, there are things you are charged differently with.
Absolutely.
Okay.
And
all right, so we're not separating out immigrants and saying, we only do this to immigrants. We do this to anybody who turns 18, right?
My son turned 18 not that long ago. I don't have access to his medical records anymore.
Yeah, we fight that battle all the time, but go on. As a parent, go on.
Yeah, with respect to determining the age of a person, it's actually very difficult. TVPRA does provide some guidelines, some guidance to identifying the age, but the fact is, somebody shows up without documents, we don't know who they are unless we can figure out unless we have some record, and we probably don't. With respect to determining the purpose for which they come, we really don't have access to their criminal records back in their home countries. We don't know what their affiliations are. I'll note that it was the Obama administration that designated MS-13 as a significant transnational criminal organization, and they noted the fact that one of the things that they do is they raise money in the United States and they send it back to El Salvador. So we've talked today about the crime that takes place in El Salvador. I know that Ms. Clark, I think it was, talked about how dangerous, Mr. Pocan talked about how dangerous it was. The funding for that crime actually comes from, some of it comes from here in the United States. We had a horrible incident in Kensington, and we're so gerrymandered, I don't know whether you represent Kensington or not, but involving a young girl who had been sex trafficked to the United States, who was beaten with a baseball bat 23 times by MS-13 members because she failed to perform adequately. They didn't hit her in the face because they didn't want to damage the merchandise that they had, but it was a horrible case, not reported. With respect to MS-13, it's all anecdotal, and in fact, I would note that the White House put out, Homeland Security, unaccompanied alien children and family units are flooding the border because of catch-and-release loopholes, but they talked about UACs providing fertile recruiting grounds for violent gangs. A 2017 review of UACs in the custody of HHS found 39 of 138, or 28%, were involved in gangs, with the vast majority of those involved voluntarily. And again, we know that these gangs recruit unaccompanied alien children in our home state of Maryland. We know that they do it in the high schools there. But again, there's no barcode that somebody has on them that you can scan that's going to tell you what their intent to come to the United States.
Before my time, I was just commenting on human trafficking. How hard is it for us to detect when human trafficking is occurring?
Human trafficking is very difficult, and let me just define the difference between the term trafficked people are involuntarily moved, smuggled are voluntarily moved. But again, identifying human trafficking, and I would see it in my own court. I would see these women who had been picked up, and I would say, did anybody force you to come to the United States? And they wouldn't break. They would not tell me. And I said, look, I can help you if you tell me, and they wouldn't tell me.
Thank you very much.
Coming to the end of the hearing, and I wanted to say to my colleague, the ranking member, would love to have you make any final comments or any, if you had any additional questions that you might want to ask.
No additional questions, Madam Chair. I want to thank all of our witnesses. Frankly, both your written and your personal testimony was compelling and extremely helpful, and I appreciate it because I think this is such a many-sided problem, and I think it's changed in ways that probably we didn't fully grasp at the beginning of this back in 14 and 15, both demographically and what that does in terms of the facilities we need, the personnel we need, frankly, the policies that we need. And you've helped all of us come to a better understanding of that. Madam Chair, I want to thank you, too, obviously, again, for the IG briefing that we had 2 weeks ago and for assembling this panel and focusing interest on this. Sadly, I think we're going to have this problem for a long, long time. And you're helping us begin to understand the dimensions of it, and grapple with it, and see what the appropriate ways to proceed are. And that's a real contribution. But again, my friend, the chair, is the one that made that possible. You wouldn't be here if she hadn't held the hearing. And so I'm, again, grateful to my friend for that, grateful for your time and your professionalism and your expertise. And with that, Madam Chair, I yield back.
Thank you so much, and thank you very much. It really is we've worked together these last several years, and will continue to do so, because in so many instances we see the difficulties that are there, and the goal for yourself and for myself is how do we address the issue, how do we try to solve what we can solve. Again, I want to just say thank you to you for what is powerful testimony. As Congressman Cole pointed out, both the written testimony and your presentations here this morning, there are many questions still to be answered. I come away with, and I just want to repeat over and over again, we on this subcommittee cannot afford to get sidetracked with issues that people want to bring up, which may obfuscate the issue at hand, which is what ORR's mission is. It is a human services agency. That is what its mission is. It is not an immigrant enforcement agency. It is not an extension of ICE, though and that's why ORR needs to focus directly on that mission. No one in the past has tried to change that mission in the way over the past 2 years that this administration has tried to change that. I can't make them up. There is a memorandum of agreement on data flowing. There is the holdup of fingerprinting, and which they had to stop because they were so overwhelmed. And we've had the largest release of 4,000 to safe havens. That's what we're about here. So that we need ORR to care for children, place them in a safe home with a family. Unfortunately, as I said, that has not happened. And the administration is trying to divert that mission. I've said on many occasions, and I will repeat it from day one when I got involved in this issue, that I believe what we've looked at over the last 2 years is government-sponsored child abuse. And we can't have that on our watch in this subcommittee. That's not where we are. Family separation, memorandum of understanding, influx facilities like Tornillo and Homestead, disregarding Flores or trying to upend a Flores, children spending months in federal custody. And we are spending, that is an appropriations, this comes under our jurisdiction, millions and millions of dollars being spent without any accountability. We've tried, we both have tried to get accounting. We just keep hearing the more resources that you need, and we're not afraid to provide resources. But as I said in my opening statement, we are not going to throw good money after bad for a continued, a failed policy that this administration has engaged in. And it is about keeping children in detention. It is a policy failure. This is a manufactured crisis. We are committed, I am committed, as I said at the outset, to continue to do oversight of this effort. The more you probe into it, the more avenues there are to be able to look at. We will call witnesses from HHS. We will call others to address this because we need to get to the answers. Because, you know, it can't continue like it is. And we have to fix it. We have to stop what's going on now, and we have to fix it. And there are models all over the country. Most recently, I heard of children who age out, that there is a model for dealing with them. I want to know, how many are there? Where are they? In what facilities are they? What is the difference? Was today I'm 17, in the middle of the night, at midnight, 18, I'm picked up and taken somewhere else. What's the story about that with less services? There are many avenues to probe. We will continue to do that. I want to thank my ranking member for his cooperation, and I just want to say again, thank you. Thank you for the great work that you are doing on behalf of the children who come to us seeking help. Thank you very much, and I want to just bring the hearing to a close. Thank you very much. Thank you so much, Tom. Thank you.